talk.
Thank you so much, Christian. And again, it's very, very good to be here with you in Hala after 20 years. I hope to return sooner next time. And I appreciate the fact that so many of you who were with us yesterday are here again today. If you were not able to join us yesterday, I understand that our proceedings are on YouTube. So if you're truly interested, you can go there later. Yesterday, in what I said, I was drawing in part from two of my books. My first book, Trade and Freedom, and a more recent book, The Willing World. Today, I'll be drawing again on The Willing World, but also on my book, Trade Links. Tomorrow, I'll be drawing on my forthcoming next book, Democracy for a Sustainable World. You'll be happy to hear that you're not required to read all of these books, and none of this will be on the final exam. But I can see from yesterday that you truly are interested in these subjects, so I'll try to help you with them as best I can, and you've already helped me with your questions and inspiring some further thought on my part about where I might want to go next. One thing I want to underscore at the outset today is the need for optimism. I believe we have a duty of optimism. I believe that there is no other way truly to live without being optimistic. And I continue to be optimistic even in a world where there appear to be accumulating grounds for pessimism. Hence the topic today. We discussed yesterday the growing clash between those who believe in the rule of power and those who believe in the rule of law. And this is intensifying in trade. It's also appearing in many other places in our geopolitics. But our topic is trade, and those of us who believe in the rule of law and trade also, of course, believe that we need rules for trade. And if we're optimistic, then we think that there is yet much we can do to advance trade in a way that will provide for greater prosperity for all the world. More than that, many of us believe that we must make trade more of an affirmative agent for achieving the broader goals of sustainable development. With this in mind, what should we be doing if indeed we could find the political will that is required to advance the trading system? First of all, in the past 29 years since we established the WTO, we have had some successes. I mentioned a few of them yesterday. I'll mention them again now. We have an information technology agreement. We have an agreement on basic telecommunications services. We have an approved government procurement agreement. We have a trade facilitation agreement. We concluded in Nairobi a few years ago an agreement to eliminate agricultural export subsidies. And we have a very good start at an agreement on disciplining fisheries subsidies worldwide. These are not small accomplishments. However, they are small when compared to what we still need to do. And as the world turns, the list of all we still need to do gets longer every day. If we had the political will, we would, first of all, of course, complete the accomplishment of the agenda that was set out in the Doha Development Round in 2001. You will recall from yesterday that this round of multilateral trade negotiations ultimately failed 15 years later. We have accomplished almost none of what we set out to do in that round, except the trade facilitation agreement. What's left? A lot's left. There is the potential makings of a grand global deal that would, on a multilateral basis, lower all kinds of barriers to trade and thus increase the volume of trade and the opportunities for more prosperity within every one of the 166 members of the WTO. What would that deal comprise? On the one hand, developed countries especially, but all countries, could reduce significantly their agricultural subsidies. I would eliminate them entirely. 30 years ago, I voted against sugar subsidies, even though I was a member of Congress from the state of Florida, the largest sugar-growing state in the United States. I have never supported agricultural subsidies, which distort trade enormously, and which, in most instances, deny to developing countries the comparative advantages they ought to have in agricultural production. So, of course, this would mean that there would have to be cuts in the subsidies in the Common Agricultural Policy, in the agricultural subsidies programs of the United States of America, in Japan, in Norway, in Switzerland, and you may not realize, in China. China now has a vast amount of agricultural subsidies that distort world trade, and that, like the subsidies in the US and the EU and elsewhere, deny to a lot of poorer developing countries what should be their rightful opportunities in world trade. There's also the matter of trade remedies. This is entirely politically sensitive in the United States, in the EU, and in some other developed countries. Trade remedies can be appropriate in the circumstances that are described in the relevant WTO agreements. But trade remedies, anti-dumping duties, countervailing duties, safeguards, are all often pernicious in their impact on the trade of developing countries, and unfairly so. In this grand bargain, the developed countries could make concessions on agricultural subsidies and trade remedies in return for concessions on the part of the rest of the membership of the WTO. These concessions could be in tariffs on manufactured goods, which unfortunately are rising everywhere with the increasing protectionism in the world, and a lowering of barriers to trade and services, where developed countries such as the United States and the EU have great comparative advantages. As it is, because in the developed world we've been unwilling to impose upon ourselves the political cost of making concessions on agricultural subsidies and on trade remedies, we have denied to ourselves the opportunities that we would have from lower tariffs on manufactured manufactured goods and lowered barriers to trade and services. So the whole world, in the absence of this bargain, is less prosperous. I would add one issue here. Every 2 years, the WTO has an anguished debate over whether to extend a moratorium on taxes on electronic commerce. At our most recent ministerial conference in Abu Dhabi, the decision was made to extend this moratorium one more time, but only one more time. Developing countries oppose this moratorium and want to preserve for themselves the right to tax electronic commerce because they have the mistaken impression that this would be in their economic interest and would provide them with an economic advantage. All studies show that they are wrong. What little revenue they might generate from taxing electronic commerce pales in amount to the great benefits that they can derive from not taxing electronic commerce. Yet they have yet to be persuaded of this. And this, as I said, is what might be called the inherited trade agenda of the WTO. These are not new issues. There is another list of new 21st century commercial issues in trade that likewise has not been addressed in any successful way. We have been conducting negotiations on digital trade in the WTO that have gotten basically nowhere. The greatest change in international trade in the past generation, since the establishment of the WTO, has been the emergence of digital trade. More and more trade every day is conducted digitally, and yet there are no rules in the WTO Treaty on digital trade. How in the world can the WTO in this day and age be considered a world trade organization if it does not have rules on digital trade? There's also the matter of competition policy. The European Union has been trying to encourage other members for nearly 3 decades now to conclude global rules on competition policy. It might, for example, address a lot of the cartels that distort trade in all kinds of unfortunate ways. So far they have not succeeded. My own country has resisted this unreasonably so. The only rules we have that approach being competition policy rules are the trade remedies rules we have, which are extraordinarily divisive and inadequate to the task of dealing with other aspects of competition policy. We need a broad group of rules relating to competition policy. There's also the matter of intellectual property. An ever-increasing portion of the value of almost every good is in the intellectual property that has gone into making it. The copyrights, the patents, the trademarks, the trade secrets, and the like. We have an intellectual property agreement in the WTO treaty, the WTO agreement on the trade-related aspects of intellectual property rights, and it's a good agreement. But it's 30 years old. There have been new intellectual property agreements that have been negotiated since that time, and these new agreements on the internet and on other topics ought, like the previous IP agreements that were included in the WTO treaty, be incorporated by reference as well. And we're not even trying to do that. There's also the issue of investment. Investment is the flip side of trade, and it's entirely appropriate to have rules on certain aspects of investment in the WTO treaty. We have rules on trade-related investment measures, but they are, at this point, likewise inadequate. With great effort, about 100 countries have concluded a plurilateral agreement on investment facilitation, which is sort of a companion to the trade facilitation agreement in like vein. But other members have blocked including that investment facilitation agreement in the WTO treaty. That too needs to be done. So we have an inherited trade agenda, and we have an additional agenda with the new commercial issues of the 21st century. But much as we need to conclude all of these agreements on these issues, I think by far the most important unmet task of the World Trade Organization is to reconcile trade with sustainable development. We need to make trade a more affirmative agent for sustainable development. And let me emphasize, it is simply not true that during the time of the WTO, trade has generally stood in the way of sustainable development. If you look at the record of the WTO, if you look at the cases in dispute settlement, if you look at other aspects of the trading system, you will see that it is simply not the case that trade has always automatically trumped the environment or other aspects of sustainable development. But that said, we have not harnessed the trading system to the extent we must do if we are going to truly make it an affirmative agent for sustainable development. I draw your attention to the very first paragraph in the preamble of the Marrakesh Agreement, which established the World Trade Organization, an agreement in 1994 that led to the establishment of the organization in 1995. In that very first paragraph, the countries that established the WTO said that they were doing so with the aim of conducting trade and economic endeavor in accordance with the principle of sustainable development. That's a direct quote. I have been accused of trying to change the original purpose of the WTO by encouraging its transformation into an active institution in pursuit of sustainable development. But that is not so. In urging this, I am simply reiterating the original intent of those of us who created the WTO. I was there and I know. The WTO was created at around the same time and by many of the same people who were at that time also attending the Earth Summit in Rio in 1992, concluding the Climate Framework Convention, concluding the Biodiversity Convention, concluding the Rio Declaration, and a lot more that advanced our environmental purposes in the world. And it is not surprising at all that these same countries at the same time wanted in the WTO treaty to proclaim their support for sustainable development. So they did. And yet, in the years since, along the way, some have forgotten that this was part of the original purpose of the institution. And I think now it is important for us to remember this original purpose, and not be content simply with not standing in the way of sustainable development, but rather do our very best to try to advance sustainable development on every front. And here I should add that it's important as part of this to understand that sustainable development, as I'm sure all of you know, is not simply a matter of environmental protection. In addition to the environmental pillar of sustainable development, there are also the social and economic pillars of sustainable development. All three of these dimensions of sustainable development are reflected in the United Nations Sustainable Development Goals. There are 17 of these goals. The first one is to eliminate poverty. I'm not sure how this can be done if you don't lower barriers to trade. The second is to eliminate hunger. Again, I'm not sure how you can achieve that goal without making certain that we follow comparative advantage in agricultural trade. There are a number of these goals that are directly related to the environment. Goal 13 is to address climate change, for example. But another aspect of sustainable development is that all three of these dimensions, the social, economic, and environmental dimensions of sustainable development, are all interrelated. They are all connected. And these are what I call, with respect to trade, our trade links, which is the title of my book. And there, I think we need to do a lot more within the WTO to make certain that the trade links are in fact linked as they should be with the right interpretations of existing rules and with the revisions that are needed of existing rules and with the negotiation of new rules. What are some of the aspects of that? Well, first of all, I would say that we have to address the links between trade and climate change. And this issue, which was once in the distant future, is now very much upon us. When I left the WTO 20 years ago, I was invited to speak to the General Counsel. I did. My topic was what I saw as the coming collision between trade and climate change. Those in the audience told me afterwards that they very much appreciated my service on the appellate body of the WTO, but that I was a bit wrong-headed in thinking that climate change was a trade issue. Not long afterwards, I returned to the climate movement in which I'd been engaged even before I went to the Congress of the United States, and had set it aside from when I went on the appellate body. And I spoke in Copenhagen in 2009 and told the climate delegates there that we were approaching a collision between trade and climate change. And I was told very politely afterwards, thank you very much, we appreciate you coming, but trade is not a climate issue. Well, now we know better, but we have yet to see either the climate regime or the trade regime grapple fully with this coming collision, which I think will be very much upon us when the European Union's carbon border adjustment measure takes effect a few months from now. Well, what should we do? Well, there's some easy fixes. There's some that are not easy at all. As it stands, the General Agreement on Tariffs and Trade, which is a part of the WTO treaty, has has a bit of a chilling effect on decisions by WTO members to enact carbon taxes. It does so because it's unclear whether a carbon tax is eligible for a border tax adjustment under Article 2 of the GATT. Forgive me for being lawyerly with you. Well, that can be remedied very easily. The members of the WTO could adopt a formal legal interpretation under the WTO treaty stating that a carbon tax is indeed an indirect tax on a product that is eligible for a border tax adjustment. That would, in one stroke, eliminate that chilling effect. What about other measures that are taken for climate reasons that restrict trade? One of the things I said when I spoke to the WTO General Counsel 20 years ago, and one of the things I've said many times since, is that in order to take the extent of climate action we must take in order to address the challenge of climate change, the trading system is going to have to permit certain climate-related trade restrictions that might otherwise be inconsistent with WTO treaty obligations. Clearly, we cannot permit measures that pretend to be climate measures but are only disguised restrictions of international trade. But in a number of instances, with not only carbon border adjustment mechanisms, but other kinds of trade restrictions, countries do and will have legitimate climate reasons for imposing these trade restrictions. And we need, for the members of the WTO, to decide where the line must be drawn between the kinds of measures that are permissible under WTO rules and the kinds of measures that are not. Toward this end, I have suggested that the members of the WTO enact a climate waiver. So far, none of the 166 members of the WTO are in favor of a climate waiver, but I predict that within several years we will see the members of the WTO turn to consideration of such a waiver as a realistic option. They will, because the other options are not very attractive. They're also limited, and furthermore, as soon as the EU imposes its carbon border adjustment mechanism, I believe we will be launched on a climate trade war. And that war will only end successfully with the drawing of that line that I've advocated. But climate change is not the only issue on which some lines have to be drawn. Equally significant, I believe, to climate change is the issue of biodiversity loss. We've just seen what was largely a failure in Colombia in the COP of the Convention on Biological Diversity. And clearly the world is not yet prepared to draw that line, just as it doesn't seem to be prepared to provide financing for the poorer countries so that they can mitigate and adjust to climate change or biodiversity loss. My own view is that in addition to the line drawing of a climate waiver, we must also draw other lines and other aspects of environmental preservation and protection of our threatened biosphere. This should be done in biodiversity, it should be done in agriculture, it should be done with respect to the forests. In these cases, and perhaps more, I think we need to condition trade on engaging in sustainable practices. Now, this is easy for someone from the richer part of the world to say. And one problem with saying these kinds of things in Europe or the United States or Japan is that in taking these measures, as justified as they may be, we will be imposing costs on developing countries that they cannot afford. If we are going to impose our will extraterritorially in trade with these poorer countries, then we must do two things, in my view. First of all, we must consult with them beforehand to try to minimize the negative impact of imposing these higher standards on the trade of these other countries. This is one of the things that the EU has not done that I think will not stand the EU well in inevitable dispute settlement over the CBAM. That's one thing we must do. The other thing we must do is provide these other countries with the financial wherewithal to do what it is that we want them to do, but they cannot otherwise afford to do. There are going to be considerable administrative costs to these types of trade restrictions arising from our climate convictions. There are going to be a lot of changes in production practices, which will also cost money. And it is neither right nor just to impose these standards on other countries when they don't have the means to fulfill these standards. And it's this point that's been missing in much of the debate in the developed part of the world over these types of environmentally related climate restrictions, which I hasten to emphasize I largely support. But there are other things we should be doing that we're not doing that address other aspects of sustainable development. For example, look at what happened on health issues in the pandemic. Did you know that the average tariff on soap in the world is 17%? Why do we even have a tariff on soap? I'm sure there's some domestic soap producers in European countries or in the United States who can explain that to me, but to me it is utterly unjustified. And we also continue to have trade restrictions that are needless on medicines. We embarrassed ourselves in the developed world with our vaccine nationalism during the pandemic. This was immoral on our part, and also it wasn't very sensible because if you're going to stop the pandemic, the way to do it is to make certain that those who are most vulnerable to it get the vaccines first so that you can stop it from spreading. We need a WTO health agreement. This too is part of sustainable development. In addition, what else have we seen in some of the economic dislocations of recent years, first with the pandemic and more recently in the wake of the Russian aggression in Ukraine, we've seen export restrictions on food. Well, this too is a practice that is perverse because it doesn't lead to more food production. It doesn't make it possible for food to be where it's needed. It distorts markets and ultimately raises prices. We need more WTO disciplines on these types of agricultural export restrictions. As I mentioned earlier, we have the beginnings of an agreement to discipline subsidies on fisheries. This is extraordinarily important. Nearly half the people on the planet, billions of people, depend on fish as their primary source of protein every day. And yet fish stocks are declining dangerously throughout the world. Well, I'm very proud that the WTO has in fact concluded a fisheries agreement. It's the first agreement ever concluded by the trading system solely for reasons of sustainability. It's a very good precedent. But the agreement itself is not nearly all it needs to be. It doesn't really discipline most of the fisheries subsidies. That needs to be done. And then I would add there's the matter of fossil fuel subsidies. Talk about perversity. Here we are as a planet trying to reduce and we would hope eliminate our reliance on fossil fuels for energy. And at the same time, we're spending trillions of dollars annually to subsidize fossil fuel production. How does that make any sense? It doesn't. It doesn't at all. The last I looked, there are 14 members of the WTO trying to get the rest of the membership to pay attention to this issue and do something about it. In my view, fossil fuel subsidies should be prohibited subsidies under the WTO agreement on subsidies and countervailing measures. Furthermore, we should change that subsidies agreement to make certain that you can countervail subsidies not only when they have economic harms, but when they have environmental harms as well. The good news is that the response in the WTO today to these kinds of issues is not the response I got 20 years ago when I spoke to the WTO General Counsel. Today we have ongoing what is called a strategic dialogue on trade and environmental subsidies. At present, there are 77 members of the WTO, nearly half of the membership of the WTO engaged in this dialogue. This includes the European Union, it includes the United States, it includes China, it includes most of what are called the major players in the system. What are they doing? Well, at this point, they're just talking. And to their credit, they're also doing a lot of listening. They're entertaining presentations from scientists, environmentalists from all over the world. They're focusing on a specific list of issues. One is environmental goods and services. We have been trying for 20 years and more to eliminate the tariffs on environmental goods. Thus far we have failed, in part because we continue to have a problem in defining environmental goods. Added to this now is a concern about the need to eliminate barriers to trade in environmental services. Think about it. How in the world can developing countries begin to adjust as they must to the changed world of climate change if they do not have access to environmental goods and services. It makes no sense not to conclude this agreement. And from the perspective of the United States and the European Union, we have comparative advantages in producing a lot of these goods and services. So it makes no sense for us not to make a priority of eliminating the trade barriers to these goods and services. But this has not been the high priority it should be. Now we have at least half the membership saying in these dialogue that it needs to be a high priority. Next is the issue of trade-related climate measures. The dialogue, which is this being the WTO, known by the acronym of TESD, is looking at some of the issues that I've discussed about where we might need to draw a line to permit some climate-related trade restrictions while not permitting others. Third is the issue of subsidies, which I've also discussed. Which subsidies that are provided for environmental reasons are permissible, which subsidies that may have environmental harms are impermissible. Where should we draw those lines? Next is, surprisingly, given the stereotypes about the WTO, the issue of a circular economy. The membership of the WTO, at least this half of the membership, is actually actively engaged in talking about how to make our economy more circular, how to eliminate waste in the economy and make sure that our production is environmentally sound. They are just getting started on that, but I find it noteworthy that they're actually discussing this issue. It flies against all the stereotypes that much of the world has about the WTO. Then, lastly, there's the issue of plastics, which is being discussed in yet another strategic dialogue that is occurring in parallel. As I'm sure all of you know, the United Nations is trying very hard to include a plastics agreement. And we seem to be getting closer to that. Meantime, the WTO is looking closely at the trade-related aspects of plastic production, plastic trade, plastic use, and trying to discern how trade rules might be changed to support the effort to keep plastics from destroying the planet. I'm sure you've all seen the latest evidence that tells us that microplastics are even appearing in the bodies of newborn infants. That's how bad this issue has become. And we cannot ignore it any longer. The hope is that these discussions, this dialogue, will, over the course of the next year or two, change and evolve into full-blown trade negotiations, which would then result in the conclusion of new trade rules. I'm working alongside many others to try to help make that happen. There is a proposal called the Vilars Framework, which I was one of the participants and which echoes much of what I said in my book, Trade Links, in proposing an agenda for making the WTO a more affirmative agent for sustainable development. But there are obstacles to achieving this. One is the consensus rule that is at the center of WTO decision-making, but often plagues it. Under the consensus rule, nothing is agreed until everyone is agreed on everything. And this means that just one of the 166 countries can keep anything from happening in the WTO. Along with many others, I have long urged that instead of trying to do everything by consensus from the outset, we instead take the plurilateral approaches that are permitted in the WTO agreement. These would be agreements among some but not all WTO members, agreements that could then over time be expanded into fully multilateral agreements that would all include all WTO members. The essence of multilateralism includes plurilateralism. Taking plurilateral approaches is simply one way of working toward eventual fully multilateral results. This has long been the case. Many of the agreements that we have multilaterally in the WTO treaty began back in the days of the GATT as GATT codes. When I first went into trade as a young negotiator, it was in the immediate aftermath of the Tokyo round, and we were charged with going around the world to talk other countries into signing these GATT codes that had been negotiated on things like dumping and subsidies and standards. Well, these GATT codes are now fully multilateral agreements, the anti-dumping agreement, the subsidies agreement, and the agreement on technical barriers to trade, from which the standards code evolved. That's one of the challenges we face. So I think it's important for all the members, even those who most ardently support multilateralism, to support plurilateral approaches, something that has not been done, unfortunately, with the investment facilitation agreement. Yes, they are right that full multilateralism is the ultimate goal, but blocking members from the WTO from concluding plurilateral agreements within the WTO does not keep plurilateral rules from being made. It simply guarantees that they will be made outside the legal framework of the WTO in non-WTO bilateral and regional trade arrangements. The result of that will be that these rules will be developed. Eventually they will expand, and the countries that are blocking anything but something that begins with a full consensus will find that they are going to be impacted by rules they played no part in negotiating. So they are, in my view, outsmarting themselves. The other and last challenge that is faced in trying to fulfill some of this lengthy agenda that I've described today is the role of the United States of America. The attitude of the United States to the WTO going forward is at this point best described as uncertain. As we discussed yesterday, both of the political parties in the United States have in recent years abandoned trade multilateralism and embraced protectionism. Will they now find a way to support any of what I've proposed today? You've situation today, then the answer seems to be no. I do not see any political desire on the part of the United States for moving forward with the inherited trade agenda of liberalizing trade in agriculture, manufacturing, and services, and more, even though it's very much in the interest of the United States of America to do so. I do not see much interest in pursuing the new commercial issues of the 21st century that I've described. One would think the United States would see that its self-interest lies in having good rules on digital trade, competition, policy, investment, and more. But this is not a priority for the United States at this time. What then about all the proposals I've made today for making the WTO more of an affirmative agent for addressing climate change? Well, the current administration has participated in the TESS dialogue, but it has not made that dialogue a priority. You would think that it would have done so given its environmental sentiments, but the U.S. has been more of a participant than a leader in this dialogue in the WTO. And it is unclear to me whether the United States will even continue to participate in the dialogue on trade and environmental sustainability in the next administration. We shall see. Well, what then should we do if the United States is not with us and is not trying to help lead the way to where the world trading system needs to go? And what we should do is simply proceed without them. I think it's true that there are certain issues that can't really be resolved unless the United States is actively engaged in resolving them. Furthermore, I think there are certain issues that at this point cannot be resolved unless the United States and China are working together to resolve them. But this does not mean that we need to sit the rest of the world and twiddle our thumbs. There is much that can be done without the United States and even without China if we work hard enough to do it. So I say we should proceed on all these fronts as best we can, conclude what agreements plurilaterally we can conclude, and work to the day when the United States will want, once again, to do what it has done so often before, which is lead the world to a better system of trade in a world in which we adhere to the rule of law and not to the rule of power. Thank you so much. I'll be happy to answer any questions you may have.
The floor is open. Maybe I can start with, you mentioned consensus rule, which of course is key with all what you described. And as an alternative, you propose plurilateral agreements, which I would subscribe as one alternative. But what about voting? I mean, Article 9, paragraph 1 of the agreement establishing WTO explicitly says no consensus can be reached. There will be vote. But nobody is willing to draw this card, actually. And that is sometimes hard to understand. One historical anecdote you might know, in 1982, as there were discussions already on a new trade negotiations round, which then led later on to the Uruguay round, a deadlock, and the US threatened with calling for a vote, and that was the only way to move forward, and then otherwise we wouldn't have WTO as we have it. But nobody's willing to do that these days, which I personally sometimes have problems to understand, because in certain issues there are large majorities that would go a certain way.
Well, like virtually everyone else who's been engaged with the WTO, my knee jerks in favor of achieving consensus. However, it is clearly contemplated in the WTO agreement that voting is permissible, and I have no personal objection to voting from time to time. Now, what are the objections to this? One is simply the cultural resistance within the WTO. The system's never voted on anything, even though it's clearly permitted. To my knowledge, you've just mentioned the only time any country's ever threatened to call a vote. There may have been one or two other times when they've talked about it, but not only has the system never voted, it's never come close to voting on anything. There are some consequences to voting that would need to be considered. For example, if a new rule is passed by means of a majority vote, and a particular country votes against that rule, and then later in dispute settlement that there's a claim that that country that voted against the rule has now violated it, that country is going to at least say that some injustice has been done. I don't know that that would be the case because the treaty clearly permits voting, but not be akin to me saying, well, I voted in the presidential election and my candidate lost, so therefore the vote was unfair. Well, the vote we just had in the United States was not unfair. It may or may not have been the right vote. So, but that's part of what democracy is about. And I would say that if an institution has a framework that permits voting, then voting is a legitimate process for use in that institution. I didn't mention it because I think it's so unlikely. The plurilateral approaches that I mentioned are also equally permitted. You have countries such as India, South Africa, that argue that WTO should only proceed with fully multilateral agreements. Well, if that's the case, why does the treaty, which they signed, permit other approaches as other means of achieving multilateralism? Good question. Who's next? Yeah.
I have a question regarding you talked about that we need a line to draw a line between trade and climate change, and you talked about your idea of the climate waiver. Could you maybe explain a bit more in detail in which situation a country, a state could enact or use this climate waiver, and would it really be a clear line in between those two?
First of all, I think this line should be drawn through negotiation rather than through litigation and dispute settlement. It's always easier for politicians, legislators, or in this case, delegates to the WTO, to say to themselves, let's just kick this issue to the courts. Then we don't have to vote on it. That's true of the Congress of the United States. I think it's true in the European Parliament. It's probably true legislatively in every free country in the world. This does not mean that the issue won't end up in dispute settlement, and since no one's drawing the line through negotiations now, my best guess is it will be drawn in dispute settlement. And to answer your question, I'll give you an illustration through a brief legal analysis of the pending European carbon border adjustment mechanism as it now stands. This is a classic case of an effort to impose trade restrictions for climate reasons. Is this legal under the WTO agreement? My friends in Brussels say it is, but then they're paid to say that, right? And they have some of the smartest trade lawyers in the world. I know, I taught several of them when they were clerks of mine. And they've done their very best to craft a measure that will withstand legal scrutiny in WTO dispute settlement. And let me say that in concept, I agree with this idea of allowing climate-related trade restrictions so long as we draw the line in the right place. So this is not meant as a criticism of the EU. I probably should also reiterate what I said earlier, that in doing so, we need to make certain that the developing countries whose trade is affected by it have a voice in terms of due process beforehand, and also are provided in some fashion with the financial and technical assistance they may need to have the capacity to comply with these new restrictions. Okay, the legal analysis. You recall yesterday I talked about the most favored nation treatment rule. This is Article 1 of the GATT. Article 1 of the GATT says that if you provide an advantage in any traded product to the imports of one country, you must immediately and unconditionally provide it to like products that are imported from other countries that are also members of the WTO. Well, clearly, if you pick and choose between different countries based on the supposed carbon content of the products they ship to you, you're going to be discriminating in favor of some countries and against others. So there's a violation right there of Article 1. Also, you recall yesterday that I said that there are schedules of trade concessions that are made where, as a consequence of negotiations, countries promise and they put in writing in their schedules of concessions that on particular products they won't charge any more than a particular amount of tariffs. Well, the distinctions that the Europeans plan on making are going to be implemented through the imposition of tariffs. If those tariffs exceed, for any given product, the amount that the Europeans have pledged as a ceiling in their schedule of concessions, that's a violation of Article 2 of the GATT. Now, I believe Article 2 of the GATT would apply because we know from WTO case law that whether a measure is a border measure or an internal regulation will determined by the point at which a particular measure is applied. In this case, a tariff, a tax. And the plan is to impose this tariff at the point of importation. Under the case law, this means that it will fall under Article 2. But the Europeans may argue that no, it doesn't. Despite the case law, this is really not a border measure, it's an internal regulation, and it therefore falls under Article 3. The difference from the European perspective is that there is a quantitative limit under Article 2 by virtue of the schedules of concessions. But there's no quantitative limit under Article 3. In my view, even if the Europeans succeed in convincing a WTO panel that this would be something that would fall under Article 3 rather than Article 2, they're still going to lose under Article 3. Why? Because in my view, there would be a violation of the national treatment obligation. If you recall from yesterday, the national treatment obligation is an obligation not to favor domestic over foreign producers of like imported products. And what does the European Union do in its emissions trading system? It provides free allowances for domestic producers. In my view, the emissions trading system is already in violation of the WTO subsidies agreement. It's just a case that no one has brought a case against the European Union on this measure. And I know that in Brussels they're trying to phase out these free allowances. They're simply getting a lot of opposition to doing so from domestic industry. If there is even any one iota of free allowances in this measure, then it's a violation of Article 3 because it will deny to the like imported products an equal competitive opportunity in the European marketplace. So we've got violations of Article 1, probably Article 2, and the alternative, Article 3. I could maybe find a few more. Where does this leave the European Union in defending this measure in the WTO dispute zone? It leaves the European Union in Article 20, the general exceptions. And here, there is a two-step process. First, you need to prove, and the Europeans would have the burden of proof here, you need to prove that the measure is of kind that's potentially eligible for a general exception. You need to prove that it falls under one of the sub-paragraphs in Article 20. Having proven that, though, you're not free, not just yet. You still have to prove, secondly, that this measure has been applied in an appropriate way, that it has not been applied in a manner that constitutes arbitrary or unjustifiable discrimination between countries where the same conditions prevail or as a disguised restriction on international trade. All right, that's Article 20 in a nutshell. I was quoting a combination of Article 20 and our case law on it. So, potentially eligible on the first step of this process are Article 20B and 20G. 20B says that there's a general exception for measures that are necessary for health. Well, there's case law on what necessary means, and basically, to be necessary, there cannot be a reasonable alternative that's available to the country applying the measure. The problem for the Europeans is that in this case there is. reasonably alternative measure is carbon tax. And the fact is, neither the Europeans nor the Americans have had the political courage to enact a carbon tax. I will say in my defense that I voted for a carbon tax in 1993 when I was in the Congress. And I will also concede that the Europeans are closer than the Americans are to doing so, because at least the Europeans have an emissions trading system, a cap and trade system. However, that reasonable alternative is available as an option for the Europeans instead of this type of trade restriction. So I don't think the CBAM would be eligible for the 20B exemption. What about 20G? 20G talks about the conservation of exhaustible natural resources when such a measure is taken in conjunction with domestic measures. Well, here I think the EU has a much stronger case. First of all, I think it's fairly obvious that clean air is an exhaustible natural resource. There's no case law on this, but I feel fairly confident in saying that WTO jurists would reach that conclusion. Also, the Europeans, whatever the other merits or lack thereof in what they're doing, are also taking this measure in conjunction with domestic measures, the ETS. And so I would argue that the CBAM is eligible for the 20G exemption. However, as I stressed earlier, this is not the end of the story. Europeans now have to go to the chapeau. They have to be able to prove that what they're doing, that the measure they're taking, is not a disguised restriction on international trade, and it's not a measure that's applied in a way that results in arbitrary or unjustifiable discrimination between countries where the same conditions prevail. Well, on the issue of it being an undisguised restriction on international trade, what about those free allowances? What about the added importation costs? By the way, that probably results in an Article 11 violation too. If we want to add another violation to the list, these administrative costs for having to impose this measure. Well, you could argue that potentially this is an undisguised, a disguised restriction on international trade. More worrisome, though, for the Europeans is the fact that this would be, as it's evolved, an arbitrary, unjustifiable discrimination. Why? Well, on what basis are the Europeans making these distinctions on carbon content? Who's going to make this decision? Well, Europe is. The EU is. What basis are they going to be used? They're going to use one of their choosing. It may be that other countries and other places or institutions have different ways of calculating carbon content. And then in terms of picking and choosing among these countries, well, I think it's pretty certain that they will impose these restrictions on China. Read the latest news. It's also highly unlikely they would impose these restrictions on their trade with the United States. That's not helpful to the EU geopolitically. But where's the basis in favoring the United States over China on these issues? Just like Europe, China has an emissions trading system. The United States has nothing of the kind. We might argue that the Chinese have been more attentive to dealing carbon emissions than has the United States if we look at governmental actions alone. And of course, that's the subject of disputes on governmental actions that take the form of measures. Measures taken by a member. And then recall what I said about due process. I was on a Zoom call some months back with a number of other so-called trade experts in which we were speaking with some of the European officials who are involved in crafting and implementing the CBAM. And I asked one of them, I said, well, what are you doing about consulting beforehand with the countries that will be affected by this measure? And his answer was, and I quote him, we're explaining to them what we're going to do. There is an opinion that my colleagues and I wrote in 1998 in something called the shrimp turtle dispute, in which the United States lost in the first iteration of the case, primarily because they had simply imposed a measure on their trading partners without consulting with them beforehand about other potential ways in which the United States might be able to achieve its perfectly legitimate environmental goals. It merely imposed its will on it. And this is contrary to something that's implicit in the WTO agreement, which is multilateralism. And the European Union is making the very same mistake here. Now, I would say that not only have I given you this legal analysis, I've given it to you for free. So I hope you will value it, even if you might disagree with it. Yes, sir.
Just as a quick follow-up, what is your opinion on some scholars suggesting that you could use the security exception of Article 21 to justify such actions?
I think that's loose.
Okay.
Yes, sir.
As we've already gone down the way of legal analysis, and we also have a lot of communities here, which basically every year have to deal with the questions of PPMs and the likeness test of Article 1 and Article 3 of the guide. I wonder, is it time now, as an alternative maybe to a waiver, to include PPMs in the likeness for the panels?
Well, let me stop you there. PPMs are already included. If you look at the definition of the technical regulation in the TBT agreement, it really includes process and production methods, for those who may be watching but don't know what a PPM is. And I mentioned the shrimp turtle case. What is that measure but a non-product related PPM that ultimately was upheld by the appellate body?
Probably only product related.
Yeah, so that issue is over. That matter's long since been resolved. It's great for a lot of law review articles in the 1990s, but it's no longer an issue.
Non-product related PPMs are still an open question. If you have non-product related.
Well, that's what the turtle measure was. It was non-product related.
Which is disputed. I would say it was product related.
No, I wouldn't. Well, the issue was the use of turtle excluded devices.
Of course,
That wasn't related to product. Product was tuna. I'm sorry, shrimp. Shrimp. That was another case. But tuna dolphin, not the one in the 1980s, but the more recent one, was another instance where you had the environmental consideration prevail. it's simply not the case that environment's lost all the cases in WTO. For the most part, the environmental side has won almost all the cases in the WTO. When it hasn't won, it's been for procedural or other reasons. Who next? Yes, sir.
Using that understanding of product-related PPMs, for example, how are they?
Well, I could be wrong, but I've judged more international trade disputes than anyone else in the world. and I wrote several of those opinions.
I'm not willing to challenge you here, but I'm wondering, how are these products then alike rather than not alike?
Well, the issue is not likeness. See, a lot of the literature on this is focused on trying to change the likeness standard. And that's a slippery slope. The better way to deal with this, and what the case law that I helped write says, is not to deal with these issues within the definition of like products, but to deal with them within the context of Article 20. Because if you start distinguishing likeness on the basis of how things are made and determining whether there's a violation or not, then where do you stop? Did the workers have a minimum wage? Did the agricultural workers get a sufficient break to sit in the shade rather than work in the sun? And on and on and on. Did that country provide a sufficient social security system for the workers who made this product? If you can distinguish between products on those kinds of bases, then it's endless. The whole system of determining whether there's discrimination or not depends on your being able to compare one set of products with another, doesn't it? So you have to have some basis for comparing them. The traditional like product distinctions of the GATT, which have been embraced in WTO jurisprudence, largely focus on the physical and chemical characteristics of the product and their likes and uses. The appellate body has opened the door to some distinctions there. For example, in the asbestos appeal, we pointed out that consumer habits and preferences can vary from one country to another. But I think that's the only door that's been opened there. And my own view is that it would be a terrible mistake to start making like product distinctions on the basis of PPMs. However, the system permits those distinctions by providing exceptions in certain cases that are set out in Article 20, so long as such measures are applied in an even-handed way. That's where the case law of the past quarter of a century has taken us. That's a very loaded question you asked. Yes, sir.
I've got a question from the beginning about the agriculture. So you said that you would advocate to get less subsidies on agriculture and therefore having more free trade. But I might see a few problems in there if non-local producers get into, for example, if non-local producers, so
non-local,
yes, so foreign producers get into, for example, our markets, for example, to get milk or flour or sugar shipped across the globe just because it's cheaper than to produce it locally, or having people that want to have local products, but it will be just too expensive to produce it because all of the farmers just can't compete with the foreign producers? And lastly, wouldn't it be a good idea to have like a strategic local production in agriculture in case of a crisis, pandemics, wars, if the trade routes would
Okay, my answers to your question are no, 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 and no. Now, on your last question about stockpiles, I think most countries have basic stockpiles of basic commodities. We do in the United States. And I imagine you do in Europe. But that can be problematic in terms of trade. A huge issue in the trading system in recent years has been the stockpiles of India. To what extent are these legitimate stockpiles against drought, famine, and to what extent are they actually implicit subsidies of local production? And what happens to these things that are stockpiled? Do they end up being stockpiled, or do they end up going into the global marketplace? This is an issue in which the United States and EU are on one side and India is on another. What you're making is basically the argument for autarky. It's an argument that says, look, in order to be perfectly safe, we have to make everything ourselves. Because if you're going to do that with food, aren't you going to do it with manufactured goods? Aren't you going to do it with everything? We've learned during COVID that you can rely too much on sole suppliers, and you can rely too much on extended supply chains. But that's not an argument for autarky. Autarky meaning producing everything yourself. It's an argument for having more than one supplier, trying to make certain that your suppliers are reliable, and for having some redundancy in your supply chains. Supply chains, of course, give rise to all kinds of other issues. How environmentally sustainable are they, for example? I think it's the intelligent way to deal with this, because I don't want to disillusion you, but the truth is it's just impossible for any one country to produce enough of everything it needs. It's not going to happen. A lot of the resources are not available equally everywhere, and countries do not have the capacity to do a lot of these things. You can and should provide yourself with some measure of security by stockpiling certain items, but insulating yourself from the rest of the world is not going to solve your problem. Also, in terms of agriculture, it's not the case that agriculture is going to necessarily be more sustainable if we rely entirely on local production. What that leads to is this: people in different parts of the world start producing things or trying to produce things in their own part of the world that are not meant to be produced there. And that therefore cause much more environmental harm, much more water use, many more environmental harms of other kinds. You just can't grow wheat in the desert. And therefore, just as we ought to rely on comparative advantage for economic reasons in agricultural trade, we also ought to rely on comparative advantage in agricultural trade for environmental reasons. Yes, sir.
I have a question, not a legal one, more a question of critical perspective, so to speak, and I'm very much interested in your point of view here. So, as I understand it, the EU now is much more prepared facing the coming.
Could you speak up just a little bit, sir?
Facing the
It
coming.
sounds like you're very eloquent, but I can't hear you.
Facing the presidency of Donald Trump. So my first question is, do you see, are we at the brink of a new era of protectionism? First question, and if so, where do you now see the role of the WTO? Do you see the WTO like declining in importance if we should be at the...
This was the topic of my lecture yesterday.
Okay,
But I'll give you a couple of highlights before we go on. One is this. Unfortunately, in the United States, it's not the fact that we have one party that is in favor of protectionism and trade and a second party that is not. What we have are two parties that are in favor of protectionism. The policies of the current administration are very similar in economic impact to the policies of the previous administration, which will now become the next administration. There's very little difference in the trade policies. There's a difference in the rhetoric that surrounds them. Perhaps one party is more polite about it than the other. I'll leave you to decide which is which. But basically, the tariffs that were put in place 6 and 7 and 8 years ago have remained in place the past 4 years. If we can believe what we've been told in the presidential campaign, we'll now see a lot more of additional tariffs. But we don't know that yet. Is that really the plan? Is that a negotiating tactic used to secure leverage to lower tariffs? We don't know. In terms of the WTO, we also don't know, which is another point I made yesterday. There are basically two possibilities with respect to the WTO and the United States position toward it going forward. One is that the position will remain more or less the same as it has been in recent years. Ignoring WTO rules when it suits the United States to do so, using them when they feel it's to their advantage to do so. In other words, the rule of power rather than the rule of law. The other possibility is a complete withdrawal from the WTO, which would have enormous negative consequences for the United States. We don't know which path will be chosen.
Thank you.
Certainly, certainly. Yes.
So today you spoke a lot about the discussions and negotiations that are going on current topics at the moment at the WTO forum. And I'm interested in your opinion on what is being done and if it's enough to hear the voices of the developing countries, because we've seen in the past, for example, with the COVID-19 IP waiver, that their positions just, well, didn't come across and were overlooked. Is there being done enough to not repeat those errors?
Well, I think it's the case that the developing countries have far more say in the WTO than they have in any other international institution. They need more say in these other international institutions. But for several decades now, developing countries have had a majority of the WTO membership. Under the consensus rule, any one of them can veto anything the rest of the membership wants to do. And they have an equal seat at the table. Now, they're not equal in global trade, and China, which is continuing to claim it's a developing country, is nevertheless in an entirely different category economically from almost every other country that claims to be developing. And as we mentioned with respect to agricultural subsidies, now committing the same sins as other wealthier countries in the world, and discriminating against the agricultural trade of the poorer parts of the world. I'm sure there are more ways that more can be done to give developing countries a voice in the institution, and I would applaud them. But it's not the case that anyone's rolling over them. I mentioned, in terms, for example, the investment facilitation agreement, it's India and South Africa that are keeping that from becoming part of the WTO treaty. They're developing countries. Yes, sir.
Thanks for your talking.
Thank you. Can you speak up a little bit?
Yes. So I have two questions. The first is I start with an example of Pakistan, which recently found new oil and gas fields, and they have now high hopes of developing with these gas fields, and what possibilities there are. So my question is, what possibilities there are to keep these fossil fuels below ground, especially in countries which still are economically quite poor. The second question
Let me answer the first question first.
Okay.
I might forget the second. First one, forget the second. I don't see what the WTO issue is with respect to what you just said. The WTO has no authority to tell any member country what it should produce and what it should not produce, nor should it have that authority. Also, this is worth noting as well, there is no entity called the WTO that's separate and apart from the membership. The WTO truly is a member-driven organization. The WTO is nothing other than the members of the WTO working together as something they choose to call the WTO. This is an important point. This is not the case with the World Bank or the International Monetary Fund, which each have some independent authority to act under their treaties. And nothing happens in the WTO unless the members want it to happen. And I can't see any member ever supporting any type of rule that would tell the countries what they could produce, what they cannot produce. This is an issue that might more likely come up under the Paris Climate Agreement, but that's not an agreement that mandates anything. It's an agreement that encourages voluntary pledges of nationally determined contributions in terms of cutting climate emissions. Pakistan has one. So to the extent there is a legal question now would be whether these plans by Pakistan would prevent Pakistan from fulfilling its nationally determined contribution as a member of the Paris Climate Agreement. But one of the problems with the Paris Climate Agreement is that there's no dispute settlement system. There's basically a name and shame kind of system when countries don't live up to their promises that they've made in their NDCs. One of the ironies of this is that since 166 of the 194 members of the Paris Climate Agreement are also members of the WTO, then when they take a climate measure that affects trade, it will fall under the jurisdiction of the WTO. So WTO jurists, in effect, become climate judges as well as trade judges. Your second question.
Yeah, I think that part of my second question you already answered. So you gave some ideas today how to make the WTO more sustainable in different ways. And concerning climate change again, what about the speed of change in the WTO and climate change tipping points? So do you see any possibilities to speed up the changes that are happening or not happening in the WTO?
Well, I wish I did. I really like us to try to speed things up as much as I can. We are very close to some very unfortunate climate consequences. I live in Florida. We've had 2 hurricanes in this season that are much larger, much more intensive, much longer lasting, and much more perilous and dangerous than we had in Florida a few decades ago. This is because of the warming of the oceans due to climate change. And this is just one of thousands of examples that we could all point to of how the acceleration of climate change is affecting every aspect of our civilization. Look at what happened in Spain recently. Look at the fires that we had this past summer in Greece, and the fires we're having in California. And now, increasingly, all of these natural occurrences are being increased or worsened by climate change. And all of our international institutions need to be reformed in order to make them more responsive to these needs. This, by the way, will be part of what I'll be speaking about tomorrow.
Yeah, staying with developing countries, you said it's not justifiable to impose barriers to trade for developing countries on the basis of climate goals, because that would be unjust. I think
No, I didn't say that. What I said is you will be unjust if you impose those measures on those countries without giving them the means to comply with them.
Okay, that makes a lot more sense. Thank you.
That is what I said. I believe I said it several times.
Yes, my question was relating to...
I also said in the concept I would support these concepts.
Yes, my question was relating to the idea that the moment we stop using or reduce our use of fossil fuels, they become cheaper on the global market. How do we make sure that they are not then used by developing countries to increase the wealth they justifiably want to build without using a system that's going to...
Yeah, right now, environmental harm is an externality of the use of fossil fuels, meaning it's not included in the price of the fuels. The purpose of a carbon tax would be to make certain that the price of that environmental harm is included in the price of the product.
On a global scale, the global carbon tax.
Well, in concept, I agree with the Director General of the WTO. Ideally, we should have a global carbon tax. I don't think we're going to have one in the next month or two. So in the absence of that, we must first of all make it clear to all members of the WTO that yes, you can have a carbon tax, and it will be eligible for a border tax adjustment and won't violate your WTO obligations. And then second, more nation states need to enact carbon taxes, and then they need to begin to work together to try to blend them together. Some of that is starting to happen with a few of them. The last I looked, we have about somewhere between 50 and 60 countries that have carbon taxation, and we have some others that have cap and trade systems. So it's not like this isn't happening at all. It's happening, it's just not happening nearly as much as it should, or as your colleague mentioned, nearly as fast as it should.
Then, last question, we should come to an end, unfortunately. Yes, please.
Good, then I think it's a good question to end, because you ended your presentation with saying that there is a lot that can be done without the US and without consensus by the US and China. I'm guessing that's through the plurilateral agreements.
Yes.
In your opinion, where do they start? What's the first thing that should be done?
Well, the European Union is, to a extent, already doing a lot of things that should be doing. I gave you a long analysis that concluded that the CBAM would likely lose the WTO dispute settlement. But I also said in concept I'm in favor of those types of trade restrictive climate measures, so long as they're applied even-handedly, and so long as those who are affected by those measures are also provided with the wherewithal in terms of money and the technical expertise to comply with it. So that's starting to happen, and I don't think that the CBAM will be the last of such measures. I think it will be the first. It's even possible that the new administration in the United States will try to impose such a measure because it restricts trade, not because they will have any particular climate concerns. If that's the case, then that measure too would fail in WTO dispute settlement. The European Union is also proceeding with its Green New Deal, and many of the aspects of that, with its ambitious goals, are measures that affect trade. Another example would be the forest regulation. Following that fairly closely, the EU is trying to decide right now, do we go ahead and implement it now, or do we postpone that for a year? Do we change it? I know there's an internal debate in the EU about that. Some of the same considerations I mentioned with respect to the CBAM would apply in dispute settlement over the forest regulations impact on other countries. Have they been accorded due process, properly consulted, as the treaty requires, before the implementation of the measure? Have they been provided by the European Union with the means to comply with the measure? These, I think, are important legal questions, but they're also important questions of justice, as I said earlier. So this could be the first step toward total agreement on the trade-related aspects of deforestation.
Thank you very much. I think in time, over time, thank you very much for this again. Very good.
One more sentence,
Yes, of course.
tomorrow I will be talking about
Yes, I was about to say that.
something other than trade. I will not be discussing trade tomorrow. I will be discussing what I see as the relationship between democracy and sustainable development, and what I see is the way in which we can make the phrase democratic global governance something other than an oxymoron. I hope you'll be with us. Thank you.
Even though that